All right, welcome back, everyone. Today's case brings us right back into familiar territory. A Kansas sovereign citizen who already managed to complicate his own legal situation once before. This is the same guy who thought he could demand an in-person jury trial while appearing over Zoom from another state. Unsurprisingly, that request didn't go anywhere. Jury trials don't work like FaceTime calls. And just when you think it couldn't get messy, he somehow picked up another traffic charge in Kansas while traveling for that very case. So yes, round two, same confidence, even fewer clues.
The name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
That's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem.
All right. This is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence.
Here's where things already start going sideways. He qualifies for a court-appointed attorney because jail time is on the table, and that's a big deal. But instead of seeing that as a warning sign, he treats it like an inconvenience. And right on cue, he decides to represent himself, which, judging by what's coming next, is about as wise as bringing a YouTube comment section into a courtroom.
Do you understand your rights, sir?
I do. Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged that for me. and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under maritime
Let's
amnesty
clear
law?
this up real quick, because this argument never changes. Kansas is landlocked. There are no oceans, no ships, no high seas jurisdiction hiding in the courtroom. This case isn't common law, and it definitely isn't admiralty law. It's statutory law. Kansas statutes clearly say you need a valid driver's license to operate a vehicle on public roads. That's it. No secret loophole. No magic words. Just rules he doesn't like.
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to
I heard
repeat
part of
for you?
what you said. So,
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me, with regards of the elements of our persona jurisdiction, and also the nature cause of action until the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime amnesty law. So I can know how to defend myself, and then I can enter my plea.
all right. Have you filed a motion for discovery in this case?
I filed in my I put a special appearance and affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the.
This right
I faxed
here
the-
is one of the most misunderstood phrases sovereign citizens love to misuse. The Sixth Amendment guarantees you the right to be informed of the charges, not to personally understand them on your own terms. If the court explains the charge and you still don't get it, that's not a constitutional violation. That's exactly why attorneys exist. And refusing help while pretending confusion is strategy usually ends the same way, badly.
A document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant in constitutional rights / benefits.
It
Is
should be
that the
like
document you're referring to?
yeah. I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a one-page document.
There's only one. It's supposed to be more. I faxed the more over there. It was supposed to be like 4 pages.
It's one page.
Yeah.
Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action being brought up.
That wasn't directed at you. And moments like this perfectly explain why reading the room matters, especially in court. Interrupting logistics doesn't make you sound informed. It just makes everything take longer.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
because I was my special appearance didn't make it. I need to resend it as well. Can I reset it so I can have a chance to resend my special appearance because it didn't make it in. I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial?
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial, like
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the.
And there it is, a jury trial request, which means, realistically, this probably won't show up on YouTube the way people expect. No live stream drama, no easy clips, just real consequences, real procedures, and no comment section to hide behind. Somehow, that realization always hits late.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st.
Before we wrap this up, I want to give credit where it's due. Big thanks to Old Squishy Gardner for digging this one up and helping bring another example of legal self-destruction into the light. If you want to watch the full case without my commentary, head over to his channel and check it out, and let him know Team Skeptic sent you. If you found this breakdown useful, hit like. If not, hit dislike. Either way, leave a comment. Subscribe, turn notifications on, and I'll see you in the next one. I'm Wes Court, and I'm out.